Wishing all the members of the bar a very happy Onam.
Happy Onam to your lordships, my lord, all your lordships.
My lord, may I have your lordship permission to mention an exceptionally urgent matter in the category, my lord? I've sent the mail yesterday for a demolition today, my lord.
Send the mail. What time did you send the mail yesterday?
3 o'clock, my lord. Yesterday, 3
p.m. Order must have already been passed in the night because I was doing that until late.
Because we are yesterday.
Impossible. Every mail which came, there's an order, but I'll check at lunch.
Very good. I'm grateful to her. I'll give the details to the postmaster. I'm grateful.
May it please your lordship. Lord, I will cover only 3 points now, my lord. The interpretation of Article 370, which according to us is the correct interpretation, subject to, my lord, meeting with your lordship's approval. Second, State Reorganization Act. And third, what are the parameters of the power of legislature during Article 356 is in force? There are some judgments which would render assistance to your lordships, and Lord, I would read those judgments. Lord, before I start with 370, Lord, your lordships would recall the submission made by some of the learned counsels, my lord, on the other side was that there was an assurance given to the princely states, and
Assurances in the statute.
there was an assurance given to the princely states, as a result of which, and according to the petitioner, in lieu of which, they chose to join the Union of India, and therefore Article 370 is the result of that promise which the Dominion of India then and subsequently Union of India made, and therefore 370 is to be treated as permanent.
Yeah.
I'll deal with that contention first, because then, my lord, 370, it would be easier for me, my lord, to persuade your lordships the view which, according to the government, is the correct view of interpretation. Lord, this question arose for the first time in the case of Madhav Rao Scindia, where the government withdrew the privy purses. At the privy purses were a bargain in lieu of which the princely state acceded to Union of India. There were two constitutional provisions, namely Article 291 and 362, which provided for the privy purses. But the central government exercised the powers under Article 366 and deleted the term princely states and construed that since princely states no longer exist, there is no question of privy purses or other privileges. The definition was princes. The lordships are not required to go into that question right now. Lord, this honorable court allowed that petition that so long as these two provisions remain on the constitution, you cannot take away the privy purses by merely changing Article 366, which is the definition clause.
Their contention is that this is what has been done by altering Article 367.
Yes.
In our case, they are trying to bring our case on parity with the privy purses case
also,
one.
Yes, but their main plank of the contention is that this was 370 was in lieu of our exceeding, right, and therefore you could not have done it. But after the judgment in Madhav Rao's India, the government repealed or
that is a constitutional amendment.
Constitutional amendment under 360. Correct. Lord, I'm saying that, Mr. Shankar Narayan. I was just about to answer that. It was a constitutional amendment. Lord, government repealed that. So the root was taken away. That is namely Article 291 and 362. That came to be challenged before this honorable court, and the matter went before the Constitution bench in case of Raghunath Rao Ganpat Rao versus Union of India, my lords. The judgment which your lordships would find
Raghunath Ganpat Rao?
Raghunath Rao Ganpat Rao versus Union of India. 1994, supplementary 1 SCC 191.
But will we not also have to look at the original Madhav Rao's India?
It is discussed here.
Okay.
It is discussed here and distinguished.
Because Madhav Rao's India places limitations on the power of the union government to use the route of an interpretation or definition provision to abrogate substantive constitutional rights.
That is absolutely a correct legal position, but for 370, which provides that you can use this route.
That's the distinction you're making.
That's the distinction, but there is one more distinction.
But you'll have to then deal with the point as to why was it necessary to take recourse to 367 then?
That when I come to 370 the interpretation, I'll deal with that. But here, in substance, if I were to summarize the ratio of this judgment in one line, the court said that any change in the constitution which brings everyone at par can never be faulted with. Princely states after formation of the Constitution of India lost their special status, and the word fraternity used in the preamble has to be given some meaning, and this has the impact of bringing all citizens at par. My lord, kindly see, my lord, that is volume 7.
Where will we find that in the case law compilation?
Lord, volume 7 of case law compilation, PDF page 537. My lord, I'll read relevant part, my lord, considering, my lord, the time constraint. I intend to complete, my lord, on this side of the lunch, my lord.
Mr. Solicitor, we'll also, after you finish this, go back to Madhav Rao 1.
Correct.
Because if you don't go through it, then, obviously there'll be there'll be a front in the rejoinder that, you have not dealt with Madhav Rao 1.
Correct. But let us see how Madhav Rao
is dealt with
here, my lord, first of all. But I will go to Madhav Rao 1, but there is nothing, because that, Lord, kindly come to page 1. so that your lordships have, my lord, the background. The two writ petitions, your lordships gets, my lord, it's page 543, PDF 543. Your lordship gets that, my lord? Yes, I am just. These two writ petitions call in question the constitutional validity of the Constitution 26th Amendment
Just
Act.
1 second, 1 second.
I'm sorry, my Lord Justice Gawai and Justice Suryakant, my Lord gets. Volumes, Case Law Volume 7 at 543, the beginning of the judgment.
Yes.
These two writ petitions call in question the constitutional validity of the Constitution 26th Amendment Act inter alia on the ground that it violates the basic structure and essential feature of the Constitution of India and is therefore outside the scope and ambit of constituent powers under Article 368. In addition, certain directions or suitable orders are sought for declaring that petitioners continue to be the rulers of the successor rulers or the successor rulers, as the case may be, and directing the respondent Union of India to continue to recognize their personal rights, amenities, privileges as rulers of their erstwhile state and also continue to pay privy purses. Your Lordships, may my Lord kindly come to the bottom of the para, which starts with, my Lord, by the said instrument, the petitioner accepted the matter specified. Does your Lordship get, my Lord, some 10th para from the bottom? My Lord Justice Gawai, my Lord, and by the said instrument, the petitioner accepted the matters specified in schedule thereto as matters with respect to which the Dominion legislature may make laws for the state and declared his intent that the Governor General of India, the Dominion legislature, the federal court, and any other Dominion authority.
I couldn't get that.
Where are you reading? I'm sorry, my Lord. I'm reading at, my Lord, page 543. My Lord, paragraph 3 at classitum F.
F, yes.
Classitum F, my Lord, your Lordship, just one line above classitum F.
By the said instrument.
By the said instrument. My Lord, court is referring to the instrument of accession signed by
the IOA, Instrument of Accession.
Sri Raghunath Rao, my Lord, or maybe his my Lord, ancestor. By the said instrument, the petitioner accepted the matters specified in the schedule thereto as matters with respect to which the Dominion legislature may make laws for the state and declared his intent that the Governor General of India, the Dominion legislature, the federal court, and any other Dominion authority established for the purpose of Dominion shall, subject to terms of the instrument exercise in relation to Kurundwad state, such functions as may be vested in so and so, so and so, so and so of the instrument, provided that nothing therein shall be deemed to commit the ruler in any way to acceptance of any future constitution of India or to fetter his discretion to enter into agreements with the government of India under any such future constitution. Subsequently, a number of rulers executed agreements of merger and transferred the administration of their states to the Dominion of India. The merger agreement was in the form given in the white paper on Indian states and it was executed in so and so. Then, my Lord, para 4.
You know, this one. There's a little bit of a background about Kurundwad state.
Oh,
Kurundwad is a very small town, very close to Sangli. And Kurundwad is on the banks of the river Krishna. And there's a very famous, there's a place of pilgrimage called Narsoba Chiwadi, where lots of pilgrims come from across the country. And once in a year, the Krishna will rise and sweep the whole town clean, because
with the town clean.
and because the Krishna is very, and the lands are extremely fertile because of the Krishna river, right on the banks of the Krishna.
Maybe that may be the reason why the human habitation must have established there near
the sources of water and
yes.
All earlier.
Or earlier
near the-
civilizations are on the bank of
Near the rivers.
river. Look, now your lordships may come to page 548, the arguments. Here, two constitutional provisions were dispensed with were repealed by way of a definition clause. Not like, unlike Lord, interpretation clause. Lord, here kindly bear one factor in mind. 370, sub-article 3, has an inbuilt extinguishing provision. 370, sub-article 3, is a provision whereby 370 can be extinguished. That's the distinction. But I'm on a little wider argument made by the other side. Para 19, the submission, my Lord Justice. The submission advanced by Mr. Sorabji, the learned senior counsel appearing on behalf of the writ petitioner in writ petition number so-and-so are thus. Article 291, 362 and 366(2). Well, 366(2) is the definition clause defining princes then of the Constitution, were integral part of the constitutional scheme and form the important basic structure, since the underlying purpose of these articles was to facilitate submission of new order and ensure organic unity of India. These articles guaranteed pledges to the rulers based on elementary principles of justice, and in order to preserve the sanctity of solemn agreements, it was only by the incorporation of these articles that the unity of India was achieved by getting all the rulers within the fold of the Constitution, and that the deletion of these articles has damaged and demolished the very basic structure of the Constitution. The covenants entered into were in the nature of contracts which had been guaranteed constitutionally and affirmed by making the Privy Purse an expenditure charged under the Consolidated Fund of India, and the use of expression guaranteed or assured by the Government of Dominion of India to any ruler as embodied in Article 291, and the expression guarantee and assurance given under such covenants or agreements as is referred to in clause 1 of Article 291 as comprised in Article 362 was a permanent feature of the Constitution, reflecting the intention of the founding fathers of the Constitution, and as such these two articles should have been kept intact. Please pause here for a minute. My Lord, these articles even remotely did not suggest that they are temporary. As against, my Lord, 370, which by its very definition says it's temporary. And I will also, my Lord, be able to attempt to demonstrate that it could never have been but for temporary. Such a drastic provision, the visionary fathers and mothers of the Constitution would never have kept it permanent, where two organs can change the Constitution the way they like. But that's a separate argument. Please see. According to the learned counsel, the deletion of these articles amounted to a gross breach of principles of political justice enshrined in the preamble by depriving or taking away from the princes the privy purses which were given to them as consideration for surrendering all their sovereign rights and contributing to the unity and integrity of the country, and that the deletion of these articles by the Impugned Amendment Act is arbitrary, unreasonable, and violative of Article 14 of the Constitution. Further, it has been urged that rulers acceded to the dominion of India and executed instrument of accession and covenants in consideration of the pledges and promises enshrined in Article 291 and 362, and that the Impugned Amendment Act is beyond and outside the scope and ambit of the constitutional power of Parliament to amend the Constitution, as provided under 368. Mr. Sorabji, in his additional written submissions, has further urged that without the cooperation of rulers, not only the territory of India, its population, the composition of the state legislatures, the Lok Sabha, the Rajya Sabha, but also constitution that was adopted on November 26, 49 would have been basically different, and that India, that is Bharat, would have been fundamentally different from the Bharat that came into being. Lord, kindly see, my lord, para 22. Mr. Salve, the learned senior counsel, contended that he was also for the petitioner, my lord, with Mr. Lord Sorabji.
But estoppel doesn't apply to him.
Pardon me?
Estoppel doesn't apply to him based on what he argued in that case.
Well, that's the my lord, privilege on this side, my lord. We are not bound by our arguments, my lord. Mr. Salve, learned senior counsel, contended that Article 291 and 362, when yes. Mr. Salve, the learned counsel, appearing, contended that Article 291 and 362 when incorporated, were intended to grant recognition to the solemn promises on the strength of which the former rulers agreed to merge with the Indian dominion, and the guarantee of privy purses and certain privileges was as a just quid pro quo for surrendering their sovereignty and dissolving their states. It has been stated that constitutional guarantees and assurances promising continuance of privy purse as enshrined in the agreements and covenants were an integral part of the constitutional scheme and an important part of the constitutional structure, and they were to be fully honored and not cast away on a false morass of public opinion or buried under the acts of states. But the impune ex specie has abolished and destroyed those constitutional provisions of Article 291 and 362, affirming the guarantees and assurances given to the rulers under those agreements. Then your lordships may kindly come to para 23. It is further emphasized that Sardar Patel, who made it clear that according to the vision and views of the constitution makers, the guarantees of privy purses, privileges, etc., were perfectly in keeping with the democratic ethos and principles of Indian people. Then the learned counsel stated that views expressed in the Constituent Assembly were unanimously accepted and there was no dissent, and that in fact the closing remarks in the debate of Dr. Patabi Sitaramaiah were only remarkably confirmatory of the permanence and indefeasibility of the aforesaid guarantee and assurances, but also went a long way in determining that the said guarantees and assurances have come to stay as an integral and untouchable part of the basic structure of the Constitution. Finally, it was said that there can be no basic structure of a constitution divorced from the historical evolution of precepts and principles on which the constitution is founded. Any effort to determine the basic structure of the constitution without keeping a finger on historical pulse of the constitution may well lead to substantial injustice. According to him, if the historical approach to the test of basic structure is kept in view, the guarantees and assurances of the privy purses, privileges, etc., granted by the constitution makers by incorporating Article 291, 362, and 36622 in the constitution framed by them would, without any doubt or dispute, emerge in their own right as basic features of the constitution which cannot be abrogated or annihilated by any constitutional amendment, etc. Now, your lordships, my lord, kindly see para 28 at page 551. The learned Attorney General of India, with regard to the above pre-constitutional agreement, stated that history of the developments leading to the merger agreements and framing of the constitution clearly show that it is really the union of people of native states with the people of erstwhile British India, and the instruments of accession were only the basic documents but not the individual agreements with the rulers, and therefore to attribute the agreements entered into by rulers as a sacrifice by the rulers is unfounded. Secondly, the nature of the covenants is not that of a contract, because a contract is enforceable at law, while these covenants were made non-justiciable by a constitution vide Article 363. According to him, the covenants were political in nature, and that no legal ingredients as the basis can be read into these agreements, and that the guarantees and assurances embodied in Article 291 and 362 were guarantees for the payment of privy purses. He has urged that such a guarantee can always be revoked in public interest pursuant to fulfilling a policy objective or the directive principles of the Constitution. That being so, theory of sanctity of contract or unamendability of Article 291 or 362 did not have any foundation. He continues to state that the theory of political justice is also not tenable because political justice means the principle of political equality, such as adult suffrage, democratic form of government, etc. In this context, your lordships can skip, my lord, the citation. Then para 29. Before embarking upon a detailed discussion on the various facets of the contentions, both factual and legal, we shall deal with the precursive point with regard to the pre-constitutional instruments of accession, the merger agreements, and the covenants which guaranteed the payment of privy purses and recognition and personal privileges, etc., and which the agreements ultimately facilitated the integration of these states with dominion of India. Then, my lord, 30, your lordships may skip its history. 31. This accession of Indian states to the dominion of India established a new organic relationship between the states and the government, the significance of which was forging of a constitutional link or relationship between the states and dominion of India. The accession of Indian states to dominion of India was the first phase of the process of fitting them into constitutional structure of India. The second phase involved a process of twofold integration, the consolidation of states into sizable administrative units and their democratization. Though high walls of political isolation had been raised and buttressed to prevent the infiltration of the urge for freedom and democracy into Indian states, with the advent of independence, the popular urge in the states for attaining the same measure of freedom as was enjoyed by the people in the provinces gained momentum and unleashed strong movements for the transfer of power from rulers to the people. On account of various factors working against the machinery for self-sufficient and progressive democratic setup in the smaller states and serious threat of law and order in those states, there was an integration of states, though not in a uniform pattern in all cases. Firstly, it followed the merger of states in the provinces geographically contiguous to them. Secondly, there was a conversion of states into centrally administered areas. And thirdly, the integration of their territories to create a new viable units known as Union of States. My lord, your lordships may, my lord, now come to para 38, my lord, at page, my lord, 554, PDF 554. Now, my lord, the Honorable Court discusses Madhav Rao, because Madhav Rao obviously was cited. That which said that privy purses are an integral part of the Constitution of India. That is one. And number two, that you could not have taken it away by merely deleting the definition of princes. These were, my lord, the two. Then 38. On May 14, 1970, the Constitution 24th Amendment Bill for abolition of the aforesaid privy purse privileges, etc., conferred under Article 291, 362, and 36622 was 366-22 was introduced in Lok Sabha by the then Finance Minister Sri Chavan. The bill contained 3 clauses and a short statement of objects and reasons. The statement reads as under: the concept of rulership with privy purses and special privileges unrelated to any current function and social purposes is incompatible with an egalitarian social order. Government have therefore decided to terminate the privy purses and privileges of rulers of former Indian states. On September 2, the bill was voted upon in Lok Sabha, but on September 5, Rajya Sabha rejected the same since the bill failed in the Rajya Sabha to reach the requisite majority and not less than 2/3 present as required by Article 368 and voting. Close on the heels of the said rejection, the President of India, purporting to exercise his powers under Clause 22 of Article 366 of the Constitution, signed an order withdrawing recognition of all rulers of the country en masse. Look, this was the subject matter in Madhav. A communication to this effect was sent to all rulers in India who had been previously recognized as rulers. So what was done was, by a constitutional order, which is unheard of, my lord, except in 370, the Honorable President virtually declared two provisions to be nullity. The presidential order, para 40, de-recognizing the rulers were questioned in Madhav Rao, Scindia versus Union of India, by filing writ petition under Article 32, challenging it as unconstitutional, ultra vires and void. An 11-judge bench of this court, by its judgment dated so-and-so, struck down the presidential order being illegal, ultra vires and inoperative on the ground that it had been made in violation of power of the President of India under Article 366(2) of the Constitution, and declared that writ petitions would be entitled to all their pre-existing rights and privileges, including right to privy purses, as if the impugned orders therein had not been passed. Here, it may be noted that Justice Mittar and Justice Ray gave their dissenting judgment. Thereupon, that they started getting privy purses. Lord, kindly come to para 77 at page 562. Rest, my lord, may not help, my lord, assist your lordships, my lord, either way. 77. According to Mr. Sorab, para 77.
Just one.
Your lordships would, I'm sorry, no, my apologies.
In the merger or the other agreements, that the President of India will recognize the ruler or something because of inheritance and otherwise. That was there.
Yeah,
That
but
was,
366.
there was some stipulation because those, the rule of primary nature and other things were all recognized in that. That's how.
Yes, but every ruler was
You are
apart
nodding
from.
the head because you argued that matter.
This guaranteed them not only privy purses, some privileges.
Correct.
All states were divided into gun salute states. Some were 21 gun salute, somewhere the smallest was one gun salute.
They did refer to presidential orders in that merger agreements also. No. At that time, there won't be any president as such.
No, my lord, there was none.
No, because at the time when the agreements were signed, they won't be.
Thereafter, the constitution was made and the honorable president was elected.
The petitioner.
No, merger agreements were signed by Dominion of India or subsequently Government of India by the Secretary, Minister of State, Ministry of State. VP Menon, Lord, essentially is the signatory.
And 75 make a brief reference.
Yes,
Para 74 and 75, there is a brief reference to all these agreements.
correct. I'm okay. But your lordships are on para. But may I read para 75, Lords? May I?
Yes, para 75.
70. Therefore, there cannot be, my lord, it is on page 561. Possibly that's what, my lord, the Honorable Court is reading. Therefore, there cannot be any justification in saying that guarantees and assurances given to the rulers were sacrosanct and that Article 291 and 362 reflected only the terms of the agreement and covenants. In fact, as soon as the Constitution came into force, the memoranda of agreements executed and ratified by the State of Union of States were embodied in formal agreements under the relevant articles of the Constitution, and no obligation flowed from those agreements and covenants, but only from the constitutional provisions. To say differently, after introduction of Article 291 and 362 in the Constitution, the agreement and covenants have no existence at all. Everything gets subsumed in the Constitution itself.
In fact, that is the proclamation which Karan Singh issued after the adoption of the Indian Constitution, that thereafter the entire relationship will be governed by the Indian Constitution.
Yes.
And all previous covenants, agreements will cease to have any application.
They are, my lord, therefore, I said, my lord, it gets subsumed. And now the final document is the Constitution of India, which we have given to ourselves. To say differently, after the introduction of Article 291 and 362 in the Constitution, the agreements and covenants have no existence at all. The reference to covenants and agreements was casual and subsidiary, and the source of obligation flowed only from the Constitution. Therefore, the contention urged on the use of the words guaranteed or assured is without any force and absolutely untenable. The next vital issue is whether the Impugned Amendment Act damaged any basic structure or essential feature of the Constitution. According to Mr. Surabji, the repeal of Article 291 and 362, which were an integral part of the constitutional scheme, the identity of the Constitution has been changed and its character has been fundamentally altered. The total repeal of these articles, coupled with an express repudiation of the guarantees embodied therein, has resulted in nullification of a just quid pro quo, which were the essence of these guarantees. He has urged that the underlying purpose of doing justice to the rulers has been subverted and breach of faith has been sanctioned. He has relied upon these judgments, including, my lord, 3 is Madhav Rao Scindia. And please see, my lord, 79. Mr. D.D. Thakur, Lord, the father of my Lord Justice Thakur. My Lord, the Chief Justice Thakur. D.D. Thakur, in addition to the above, has stated that one of the tests to determine whether the provision of the Constitution was intended to be permanent or could be deleted or amended is to see whether the Constitution makers had intended that to be made permanent. In support of this submission, he placed much reliance on the observations of Justice Mudholkar in Sajjan Singh. My Lord, I can skip that. And thereafter, my Lord, I may directly come to 88 at page 563. Your Lordship has My Lord Justice Govai and Justice Surya. Mr. Soli Sorabji, in support of his contention that Article 291 and Article 362 and Clause 22 of the Article 366 were integral part of the constitutional scheme, which otherwise would mean the essential part of the constitutional scheme referred to Webster's Dictionary and Collins' Concise Dictionary, and has pointed out the lexical meaning which says the integral means essential, and therefore, according to him, the total abolition of provisions of the Constitution, which are in its integral parts, otherwise essential parts, has damaged the essential and basic features of the Constitution. To draw strength for his submission, he relied upon certain observations made by Justice Shah in his judgment in Madhav Rao, observing, now Madhav Rao is dealt with, and distinguished by the provisions enacted in Article 366(22), 291 and 362 of the Constitution. The privileges of rulers are made an integral part of the constitutional scheme, and an order merely derecognizing a ruler without providing for continuation of the institution of rulership, which is an integral part of the constitutional scheme, is therefore plainly illegal. The learned Attorney General has vehemently opposed the above submission, stating that the expression integral part of the scheme of the Constitution used in Madhav Rao are not the same as the basic structure, and that expression has to be read in the context of a challenge to the ordinance which sought to render nugatory certain rights guaranteed in the Constitution then existing. It is further stated that the attack on 26th Amendment based on principles laid down in Madhav Rao is totally misconceived, because only in order to overcome the effect of that judgment, the 26th Amendment was passed by Parliament in exercise of its constituent powers. The President exercised executive power, which he did not possess. Just to contrast, Article 370 has a constituent power in the President under sub-Article 3, the self-extinguishing provision. According to the Attorney General, the observations in the said case were nullified by the amendment, and the judgment is no longer good law after the amendment. To test the amendment on the basis of that judgment is impermissible, and all the arguments based upon this case are therefore misconceived. Then 91. After the commencement of the Constitution, in pursuance to Article 36622, the rulers were recognized and they had been enjoying the privy purses, privileges, dignities, etc. on the basis of relevant constitutional provisions. Pursuant to the resolution passed by All India Congress Committee in 1967, the Union of India introduced the 24th Amendment Bill in 1970 to implement the decision of the All India Congress Committee favoring the removal of privy purses, privileges, etc. But the bill, though passed in Lok Sabha, failed to secure the requisite majority in Rajya Sabha, and therefore it lapsed. It was only thereafter that the President of India issued an order in exercise of powers vested in him under Article 366(22), changing the definition clause by an ordinance. I'm sorry, my Lord Justice.
Please continue.
I'm sorry. 36622 de-recognizing the rulers and stopping the privy purses, privileges, etc. enjoyed by the rulers. Now, this is important, my Lord. This is the distinction. This order passed by the President was the subject matter of challenge in Madhav Rao 2. The Supreme Court struck down the order of the President as invalid, as in the view of the Court, de-recognition of rulers would not take away right to privy purses when Article 291 and 362 were in the Constitution. This is the ratio, that you can't delete a definition while retaining the constitutional rights guaranteed under 291 and 362. It was only in that context the observations which have been relied upon by Mr. Sorabji were made. The 26th Amendment itself was passed by Parliament to overcome the effect of this judgment. Now, by this amendment, Article 291 and 362 are omitted. Article 363A is inserted and Clause 22 of Article 366 is amended. Therefore, one cannot be allowed to say that the above said omitted articles and amended clause were the essential part of the constitutional scheme. So they have to be read only in the context of a challenge made to the presidential order, which sought to render nugatory certain rights guaranteed in the Constitution, which were then existing. In any event, the constitutional bar of Article 363 denies the jurisdiction of any court in disputes arising from covenants and treaties executed by the rulers. The statement of objection reasons of 26th Amendment clearly points out that the retention of the above articles and continuation of the privileges and privy purses would be incompatible with the egalitarian society assured in the Constitution, and therefore, in order to remove the concept of rulership and terminate the recognition granted to ruler and abolish the privy purses, this amendment was brought. Now, 92 is very important, Lord. Lord, which would also assist your lordships on the question of federal diversity. We are of the opinion that the observations of Justice Shah in Madhav Rao that privileges of rulers are made an integral part of the constitutional scheme, and that the institution of rulership is an integral part of the constitutional scheme must be read in their proper context. That was a case whereby a presidential order, the rulers were deprived of their privy purses and other privileges while keeping Article 291 and 362 intact in the Constitution. This doesn't arise here, my lords. Indeed, the said presidential order was issued after the government failed in its attempt to effect an amendment on those lines. It is in that connection that learned judge made the above observations. It is clear that the learned judge used the word integral part in their ordinary connotation, not in lexicographical sense. Ordinarily speaking, integral means of a whole or necessary to completeness of a whole, and as forming a whole. Our Constitution is not a disjoint document. It incorporates a particular socio-economic and political philosophy. It is an integral whole. Every provision of it is an integral part of it. Even the provisions contained in Article 21, temporary, transitional, and Part 21, temporary, transitional, and special provisions. One may ask which provision, which concept, or which institution in the Constitution is not an integral part of the Constitution. He will not find an answer. To say that a particular provision or a particular institution or concept is an integral part of the Constitution is not to say that it is an essential feature of the Constitution. Both are totally distinct and qualitatively different concepts. The said argument is really born of an attempt to read a judgment as a statute. One may tend to miss the true meaning of the decision by doing so. We may say the aforesaid observations of Justice Shah constituted the shit anchor of the petitioner's argument relating to the basic structure. My lord, just similarly, federalism is also, my lord, a basic structure. But the federal diversity can still exist within federalism. But my lord, that's a separate issue. In the above premise, it is not permissible to test 26th Amendment with reference to observations made in Madhav Rao. Lord, now kindly come to para 96 at page 566. Yeah. Permanent, your lordship, yes. Para 96. at page 566.
Yes.
Permanent retention of the privy purse and the privileges of rights would be incompatible with the sovereign and republic form of government. Such a retention will also be incompatible with the egalitarian form of our constitution. That is the opinion of the parliament, which acted to repeal the aforesaid provisions in exercise of its constituent power. The repudiation of the right of privy purse privileges, dignities, etc., by deletion of Article so and so, which the recognition of the rulers and payment of privy purse are withdrawn, cannot be said to have offended Article 14 or 19 1F. And we do not find any logic in such submission. No principle of justice, either economic, political, or social, is violated by the 26th Amendment. Political justice relates to the principles of right of the people, that is, right to universal suffrage, right to democratic form of government, and right to participation in political affairs. Economic justice is enshrined in Article 39 of the Constitution. Social justice is enshrined in, well, Lordships can skip that, 97. A serious argument has been advanced that the privy purse was a just quid pro quo to the rulers of Indian states for surrendering their sovereignty and rights over their territories, and that move for integration began on a positive promising note, but it soon degenerated into a game of maneuver, presumably as a deceptive plan of action. This argument, based on the ground of breaking of solemn pledges and breach of promise, cannot stand much scrutiny. To say that without voluntary accession, India, that is Bharat, would be fundamentally different from that Bharat that came into being prior to the accession is untenable, much less inconceivable. Please mark this, Malad. Beautiful words. One should not lose sight of the fact that neither because of their antipathy towards the rulers nor due to any xenophobia did the Indian government entertain the idea of integration, but because of the will of the people. It was the people of the state who were basically instrumental in integration of India. It would be apposite to refer to the observations of Justice Bose in Virender Singh judgment. Every vestige of sovereignty was abandoned by the dominion of India and the states and surrendered to the people of the land, who, through their representatives in the Constituent Assembly, hammered out for themselves a new constitution in which all were citizens in a new order, having but one tie and owing but one allegiance, devotion, loyalty, fidelity to the sovereign democratic republic that is India. Thereafter, it is also worthwhile to take note of the historical process of states integration. Lord, your Lordships may directly can come to 109 at page 569, 107. On a deep your Lordship gets me, my Lord. Para 107. On a deep consideration of the entire scheme and content of the Constitution, we do not see any force in the above submission. In the present case, there is no question of change of identity on account of 26th Amendment. The removal of Article 291 and 362 has not made any change in the personality of the Constitution, either in its scheme or in its basic features or in its basic form or its character. But please read 370 in this. Does it change the personality of the character of the Constitution? The question of identity will arise only when there is a change in the form, character, and content of the Constitution. In fact, in the present case, the identity of the Constitution, even on the test proposed by the Council for writ petitioners and interveners, remains the same and unchanged. Sri So-and-so has contended that by removing the real and substantial distinction between erstwhile princes forming a class and the rest of citizenry of India, the constitutional amendment has at one stroke violated the basic structure of the Constitution as reflected both in Article 14 and 51C and treated unequals as equals, thereby giving a go-by to a solemn treaty obligation which was sanctified as independent constitutional guarantee. 109, my Lord, this is very, very important and crucial for our purpose, my Lord, the purpose of the respondents. After carefully going through the above decisions which relate to service matters, we are afraid that such an argument as one made by Sri So-and-so could not be substantiated on the principles laid down in these two decisions, that Article 14 will be violated if unequals are treated as equals. In our considered opinion, this argument is misconceived and has no relevance to the facts of the present case. Please note this. One of the objectives of the preamble of our Constitution is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It will be relevant to cite the explanation given by Dr. Ambedkar for words fraternity, explaining that fraternity means a sense of common brotherhood of all citizens. No region, no part of the region, no citizen staying in any region should get any different treatment than rest of the country. In a country like ours, with so many disruptive forces of regionalism, communalism, and linguism, it is necessary to emphasize and re-emphasize that unity and integrity of India can be preserved only by a spirit of brotherhood. India has one common citizenship, and every citizen should feel that he is Indian first, irrespective of other bases. Therefore, I started by saying that a psychological duality in the mind is now completely gone. In this view, any measure, please mark this, in this view, any measure at bringing about equality should be welcome. There is no legitimacy in the argument in favor of continuance of princely privileges, since we have held that abolition of privy purses is not violative of Article 14. It is unnecessary for us to deal with the cases cited, which according to him go to say so and so. Then 1110. One of the arguments advanced by Mr. D.D. Thakur is that the Constitution should be read in the context of a pluralistic society of India, where there are several distinct and differing interests brought together and harmonized by the Constitution makers by assuring each section, class, and society preservation of certain political, cultural, and social features specific to that class or section. By way of example, reference to Article 370, which confers a special status for Jammu and Kashmir, is made. He continues to state that likewise in the northeastern states, the tribals were given autonomous powers for their district councils co-equal to what is conferred on the states, and that the minorities special provisions are made in Article 30. Besides, Article 25 and 26 are meant to safeguard the minorities and religious denominations. The persons to determine the injury will be those for whom these provisions were made and whose interests are prejudiced. According to him, in such a circumstance, the assurance and guarantees given under Article 291 and 362, which are the Magna Carta, assuring the rulers of their pre-existing rights, cannot in any way be destroyed. We do not think that the aforesaid special provisions have any relevance here. As repeatedly pointed out supra, the only question whether there is any change in the basic structure of the Constitution by deleting Article 291 and 362 and by insertion of Article 363A and amendment of Clause 22 of 366. We have already answered this question in the negative, observing that the basic structure of the essential feature of the Constitution is or are in no way changed or altered by the impugned amendment. We cannot make surmises of its ifs and buts and arrive at conclusion that Article 291 and 362 should have been kept intact as special provisions made for minorities in the Constitution. It is but a step in the historical evolution to achieve fraternity and unity of the nation, transcending all regional, linguistic, religious, and other diversities, which are the bedrock on which the constitutional fabric has been raised. The distinction between the erstwhile rulers and the citizenry of India has to be put an end to so as to have a common brotherhood. The court traces it to fraternity mentioned in the preamble. Lord, even removal of some provision according to this judgment can further the constitutional objective and can be in furtherance of the basic structure of the Constitution. fraternity, equality is a basic structure of the Constitution. It's a part of brotherhood. It's a part of equality, part of fraternity. And if any provision which keeps out of the total composition of our Constitution as an appendage, as a transitory provision, to be removed at an appropriate stage, if it is removed, it furthers the basic structure and it enhances the equality and fraternity, which is the bedrock of the Constitution.
Yes.
So, my lord, in this view, my lord, in my respectful submission, may not be necessary to read Madhav Rao Scindia judgment. If your lordship would wish me, my lord, I can assist your lordship with that. But we will, my lord, ultimately read the same paragraphs based upon which, my lord, it is distinguished. That when you are doing something, earlier, my lord, it was done by a presidential order in Madhav Rao. One definition was deleted, which the president did never possess. Even today, it doesn't possess. But only in one provision, that is 370, where you can amend any part of the Constitution. So, explanation 367 mechanism is used. So, this is the drastic nature.